Any mention?
May please, Lordships, I beg to mention item number 7. I would prefer 2 weeks' time, Lordship, in this matter.
7, 2 weeks.
Obliged, Lordship.
Your Lordship, I beg to mention item number 3 on behalf of LLC M. Sharma, Your Lordship.
3 weeks.
Obliged, Your Lordship.
To mention item number 5, joint request. Joint item number 5, Lordship.
Item number 5.
This matter has been part heard, isn't it?
Part heard already. I have submitted my written synopsis also. So matter may come up next week, Lordship. Mr. Gurung is having some difficulties.
Oh. 1 week. Excuse me. 1 week more. No. 25. Joint request.
Item number, my lord, item number 6. 6 as well, Lordship.
6, my lord. Item number 6 and 8, my lord, I beg to mention.
Okay, first 6. Joint request. 2 weeks.
Highly obliged, my lord. 8, yes, 8 also, my lord. Mention.
2 weeks.
Maybe 3 weeks, Your Lordship.
3 weeks.
Obliged, Your Lordship.
Practically nothing.
My lords, I beg to mention item number 9 of the daily list. Senior counsels having personal difficulties, my lord.
Who's there? Who's there in 9?
State is not here. Number 9.
Sen Gupta. Silaj, she's not here. 3 weeks.
Much obliged.
And supplementary list, item number 1.
Also, the orders, main list. We'll go with main list first, order portion, then we'll come to the.
Please, Your Lordship, pray for time.
Just you.
From daily
Item
list,
number 1.
item number 1.
Supplementary number.
Just we'll call up later. First, we'll finish with the order portion.
Lordship, this case is fixed for filing of paper books, which is not yet ready. I need 2 weeks time. In the meantime, Lordship, there are 3 convicts in this case. Through legal aid, I think they have filed an appeal, which is going to be listed. So in my case also, I need 2 weeks time to file a paper book.
You deal with your own case.
Yes, yes.
Mr. Kurishil and counsel for the appellant has sought for some more time to file the paper book on the ground that the same is not prepared, not yet, could not yet be prepared. On permit, this is matter of 2 weeks.
2 weeks.
Item number 2.
Lordship, paper is.
Please, Your Lordship, we are asking for time, Your Lordship.
Or you're supposed to file those
Yes,
authorities?
yes, Your Lordship. So maybe come up on Monday, Your Lordship.
You are not in this case.
Our Guru is the counsel, my lord. He is in court number 1, lordship.
Prosecution has started or not yet started?
Not yet, lordship.
Not yet.
Not yet, lordship. So 1 week, lordship, he will.
One week.
1 week, lordship.
On premier by the parties, less is matter to 1 week.
Item number 2. Any mention?
Yes, please, the lordship.
Yes.
I'd like to mention item number 4 and 5 and for the petitioner on behalf of V. Kumar. The matter may be fixed after 2 weeks.
It's an old matter. Why are you taking time?
Sorry?
I said, why are you asking for time when it's a very old matter?
The council has some personal difficulties, lordship.
What is this case about?
This is a pension matter.
You are Miss
A. Bora.
Ivora, Learner Council, has sought for accommodation on behalf of the petitioner on the ground that the Learned Conducting Council, Mr. V. Kumar, is indisposed. This Learned Council appears for the respondent. On premier to see us along, list this matter up to 2 weeks.
Obliged, lordship.
May I please, your lordship? I beg to mention item number 10. I pray for 2 weeks' time, your lordship.
You are for?
Respondent number 3.
Who is the respondent number 3?
Respondent number 3 is like Darbar in this matter.
This is a land acquisition matter.
Yes.
And at that time, there was a committee formed, my lord, who negotiated with the state government. And this is a committee which comprises of the CM, the Darbashno, and the village.
Darbar.
It's a committee.
Even the petitioners are not the landowners.
Yes, Your Lordship. We are not landholders. We have filed in a representative capacity.
So who are the actual landowners then?
Your
All
Lordship.
the actual landowners have got this, my lord, a compensation. This case has been filed 1 year after the compensation was released.
Your Lordship, the title
was it for recovery?
No, my lord, they were contesting the compensation, my lord, the land acquisition, but they have came before,
Yeah,
my
but
lord.
why
This case actually from day one we have said that it is not maintainable, and if lordship will have the affidavit, we have got all the details. So nevertheless, my lord,
I think we are very much aware, you see, of the process.
Yes, lordship.
If it is if it involves a land acquisition, if it is under the old act, if there's any issue as regard ownership, possession, title, so on and so forth, then section 30 is there.
my lord.
Mine. Yes.
And that should be agitated before the special judicial officer.
Yes, my lord.
Yes.
Why come before this court?
Your Lordship, there are a complex set of facts, Your Lordship. Even in the compromise decree from which the committee derived its title, the rights of the local populace was also recognized. And Your Lordship, the petitioner during the whole during the time when the facts were prevailing, the petitioner was the CM of the concerned Darbar. For that reason, Your Lordship, if we could be given a hearing, we would like to satisfy Your Lordship.
I think you have to establish your locus.
Look, my
That
lord.
is,
Yes.
that is the first thing, my lord.
Okay. 2 weeks then. 2 or 3 weeks.
Much obliged, your lordship.
2 weeks, Your Lordship.
On premier with the parties. This is matter after 2 weeks. 3 weeks. I don't think we'll be able to do it this year.
Deeply obliged.
Great for the Lordship.
Daily list item number 1.
My lordship, I have received the paper book.
The paperwork is
Already received.
given. Your Lordship. Fix the matter for hearing, Your Lordship. In the meantime, Your Lordship, the interim stay for the Miss case be extended, Your Lordship.
My lordship, the matter may be covered after vacation.
It has to come, yeah, I think.
Much obliged.
Land councils have submitted paper book, Learned Counsel for the Learned Counsel for the appellant has submitted that the paper book is ready and the matter can be finally heard. Miss Learned Counsel appears for the. You appear for, how many respondents are there?
3, my lordship.
3.
I'm
You're appearing for all?
Yes, my lordship.
Learned Counsel for the respondent has also submitted that the paperwork has been received by the respondent and the matter can be heard on merits. Accordingly, as prayed for, this is matter for hearing after vacation. In the meantime, the interim order passed earlier will remain in place till further orders.
Item number 2.
Your Lordship, in this matter, steps has been taken, Your Lordship. For respondent 1, service has been effected, Your Lordship. However, for respondents 2 and 3, they have returned unserved.
So what do we do?
Your Lordship, in this matter, the respondent 1 is the main party, Your Lordship.
Have you filed the affidavit of service?
No, not Your Lordship. I'll be filing on the next day, Your Lordship.
Mr. Learned Counsel for the applicant has submitted that the notice issued upon the respondents, upon the respondent 1, have been affected. However, it is prayed that some time may be allowed for the service report to be filed. Last time also you were given time to file the service report?
No, Your Lordship, we were waiting for the outcome of the... We were waiting for the outcome, Your Lordship, because it was not delivered on the as per the last date.
As far as respondent 2 and 3 are concerned, it is the submission of the Learned Counsel that the notice issued upon such respondent have not yet been, could not be affected. Are you taking fresh steps then?
I'll take fresh steps, Your Lordship.
It is prayed that fresh steps for issuance of notice upon such respondent be allowed. Pray allowed. This is matter after 3 weeks.
Obliged, Your Lordship.
Item number 3.
Yes.
May please, Your Lordship. Also, I appeal this matter may be adjourned for Your Lordship. The Learned Advocate General is leading a matter is on legs before the Honorable Supreme Court, Lordship.
No objection.
Mr. H. Leonard Additional Synergy has sought for accommodation on the ground that the Leonard E.G., who is leading the matter, is indisposed for the day. Mr. Leonard Counsel for the petitioner has no objection to the prayer made. Accordingly, as prayed for, this is matter up to 1 week.
Much obliged.
Item number 6.
Yes, Mr. Sahu, you have completed your argument.
Yes, yes, I have submitted.
You have completed.
Yes.
Then who is to reply?
Actually,
Would
the
you-
last date, my lord, it's the last day. Your lordship wanted to see the date of completion and when that has been intimated to the department. So that is available in page number 36. The completion.
Your Lordship, I'm praying for some accommodation. Your Lordship, Dr. Muzika, he's on legs before courtroom number 1.
My lord, that's page number. Page number 13, sorry, page number 13, 13 in WBC number 444 of 2022 in compilation, in written argument for petition. Page number 13.
There are connected matters here.
Oh, is a connected better too. Page number 13. On 6th September 2014, the contractor intimated in paragraph number 1 that sir, the work which has been allotted to me by PWO number so and so dated 24th July 2008 has been completed in all respect with full satisfaction of the department within the period of completion extended up to 30th June 2013. By 2013, June 13, that was completed and intimated on September 2014, along with the bill to the department. And department has, till then they have not taken anything, neither raised any objection nor dispute, nothing. They are keeping silent. My humble request in this case, necessary direction be issued to complete the final bill and refer to the central authority for releasing the payment. This is the only case here.
You are supposed to receive payment from which is the
payment authority, central government, National Highway Authority,
okay.
Eastern Zonal Office in Guwahati. After receiving the final bill with approval from the state government PWD, they will issue the payment. Only last payment is pending. Partly 3 bills were released. Last final bill is pending and escalation clause, that is where cost of escalation, that is also pending, and earnest money and retention money that is held up, that is to be released by the department. There is no dispute in this matter. Only they are keeping silent without any action.
Yes, sir.
Your Lordship, in fact, if I may point out, this had come from courtroom number 2. Learned DSJ had started his arguments in courtroom number 2. But Your Lordship, today is not available. He's on legs before courtroom number 1. If Your Lordship may kindly accommodate us for 2 weeks, Your Lordship.
This is an old matter. So we'll, if not today, then we'll have to take it up next week.
Yes, in next week, 2nd or 3rd December. Third December is possible.
Kanu? Certainly. On pre-made by Ms. Lorette, counsel for the respondent, Union of India, seeking accommodation on the ground that the Lorette DSGI is indisposed. The same not be objected to by Mr. Lorette, counsel for the petitioner. Matter is adjourned. This is matter on 3rd December. 3rd December.
Yes, 3rd December.
Deeply obliged, Your Lordship.
Item number 8.
May please Lordship. This is coming against the impugn order passed by the chief executive member of Garo Hills District Council. Now, in this matter, my lord, what happened is that the impugn order that we are challenging is that the chief executive member, he has passed the order. The EM has registered the petitioner hearing as a nokma of one particular akang, and against that particular akang, they have come and filed an application for filing an appeal against the order after 9 years, my lord. And then secondly, lordship, while filing the application for continuation of delay, they have filed it under wrong provision under Limitation Act, where there is a specific provision under Garo Hills Council that rule is there, lordship. So but then they have filed it on the wrong section of law, and then no proper explanation has been given, your lordship.
What is this case about?
No, your lordship, yes, first let me take you to the annexure. Page 27 of my. Before that, I will come to the page 25 of my writ petition.
25.
Yes. Now may I read, your lordship. This one. This is type copy. The original copy is page 24. The type copy, it says that translation from Garo to English, memo so and so to Chigan Sangma, Kocha Marak, Prem Sangma of Daribokri Eleka, Mungrang. This is to inform you that since you have been occupying in Daribokri village for long time, therefore you are given a permission to stay in Daribokri Akung. This is the office, and this is since from 1948. 1948, I have been occupying the land, and this is approved by the deputy commissioner, by the then deputy commissioner. Since then, the petitioner hearing and their predecessors have been occupying the Nokma, and they have been registering as a separate Nokma. Now, my lord, thereafter, my lord, when the predecessor, the Nokma passed away, the petitioner hearing and her husband have filed an application before the EM court for registering as a successor Nokma of that particular Nokma of Daribokri Akung, my lord. And prior to, on receiving the application, my lord, the executive committee, Assi Land and Revenue, they have directed the Mojanda to issue notice to the neighboring Nokmas. Now, the page 3, that Annex 3, my lord, that is the notice. May I read, your lordship? This is the notice that translated copy, and this one, page 27, my lord, page 27, page 27.
Yes.
Now, this is the notice prior to passing of any order by the EM. Here it is mentioned that notice with regards to the petition filed by the Splinter. Splinter is my husband. Splinter Aring, resident of Daribokri village, for preparation of boundary on Daribokri Akung, which he has inherited from his father-in-law and mother-in-law, led Ramsang Sechmarak and Rimji Tisangma, after the death of his father-in-law and mother-in-law, who occupy and possess the Daribokri Akung. Memo so and so, the reference memo so and so. Now the application, Sri Splinter of Daribokri 3-32 Eleka, PO so and so. This is the copy So this is our concern. This Rimjing Marak Nokma of Mandargri is the Nokma of Mandargri is the Rimjing Marak. Then the PO Songsak so and then second, my lord. Second, who is this Balen Marak from Balen Marak Nokma of Mandargri. Then PO so. Disan M Marak of Mandargri. Then number 4, Dikchon M Sangma of Mandargri. Now, my lord, on the basis of this notice, the motion have conduct an inquiry. In the where conducting the inquiry, I will not read the entire part of the inquiry report, but I will like to come to the page 32 of the report, my lord, where they have reflected in the page 32 is a type copy. Lordship.
You're just referring to this one.
This is irrelevant submission.
You tell me in brief.
The fact is this, my lord. The fact is this.
No, let him.
I will just point out, my lord. Going to the merit of the case, who was supposed to be in Nokma or who is supposed to be in Nokma, that has to be, just a minute, please.
I will come to that point,
please.
My lord.
That has to be decided by the EM and CM, my lord. This honorable court cannot go into the merit of the case by laying an evidence and all. The case was this, my lord. An application of delay of condonation was filed by the private respondent, and that delay has been condoned. Against that application, my friend is here. So going into the merit will not suffice, my lord. Only things, my lord, he has to show that the delay which was condoned, my lord, by the CEM was not correct. That is what my friend has to project before this honorable.
Lordship, I am trying to come to that point. Why I am making submission? Because the impugn order, the very ground that taken by the private respondent before the CEM was done, the notice was never served to the private respondent. That was my point.
Those are matter of merits.
Yes. Matter of merit, but they have taken the ground that saying that we are filing the continuation application because their contention was that the order was passed ex parte. That's what I am trying to. Okay. So here in this document,
see now. You are trying to say that your predecessor in interest was the Nokma of this king.
Yes.
Okay.
Now also I am Nokma, yes.
Okay. So after them, you became the Nokma.
Nokma.
Then along the line, what happened is there was a claim.
No.
By the respondent.
They are from separately from different akang from the neighbor only. They are not claiming for Nokma. They are saying that since some portion of land that is separate altogether, and that's why I am trying to read it. What my case is this.
If that is the case, then how would it affect you?
Yes, lordship.
Unless and until your right has been infringed, unless and until there was any adverse orders passed against you, then you cannot approach the appropriate authority.
Exactly, madam.
See, so now, what I wanted to know, rather what this court wanted to know is this. What is the case of the respondent against you? When forget about the application for condonation of delay, that is a different proceeding altogether.
Yes.
What is the crux of the matter?
The crux of the matter.
How has your right been?
Yes.
Been infringed?
Yes. Now the private respondent hearing, my contention from the day I have been agitating right from the EM court till the chief executive and even before this petition is that the notice was served. Before I will come to that point also. Notice was served the respective party. The rear party is a neighboring Nokma is a Mandargri.
Okay.
Now the Mandargri the rear Nokma has come and he participated in this one and he has no problem. Now that person who filed an application for continuation of delay, he wanted to file an appeal, but there was a delay of 9 years. That person has no locus standi. He is not even a Nokma.
Exactly.
That is what we have projected.
But who's to decide that?
Yes.
As Mr. Day,
Lordship, that's why I have enclosed the High Court order also was there before.
As Mr. Day has said, if the appropriate authority is the district council, so the matter has to be agitated before district council.
Exactly.
Yes, EM or CM, whatever the case may be.
Yes, Lordship, that is correct. But the thing is that that in that application for continuation of delay, instead of stressing on delay. They have touched the merit. They have mentioned all those that is the Nokma, this that.
True, but
That's why. But basically, Lordship,
who is to decide that question? It is the district council. No?
it will be the
So
district council.
have you approached the district council?
We have approached.
No, my lord. My friend is not
Lordship,
in a position to give the correct facts, my lord. The
report
EM has passed an order, my lord, in favor of my friend. Against that order, the private respondent wanted to go to the CEM, my lord. But they came to know in a very belated stage that there was an order of the EM.
That's
Yes, my lord. So when they file an appeal, my lord, a delay of condonation application was also filed under the Limitation Act. Whereas limitation is not applicable, and my friend is very much aware. In his case only, a coordinate bench of this honorable court has passed an order that Limitation Act is not applicable. That is there, my lord, in his favor, my lord, and he is aware of that. Now, if Limitation Act is not applicable, even then a condonation application was filed, and there was a delay of something around 3,000 days, my lord. Now, CEM has taken a ground for condoning the delay that day was not aware. It was an ex parte order. Wrongly, rightly, EM has passed an order. They are saying that the summon was not issued and all, my lord. That is again a matter which the CM has to decide. Whether, because lower court record is not before this honorable court, whether a notice was received by the private respondent or not, my lord. Now, if private respondent is aggrieved by the appointment, they cannot be, my lord, there should be a forum where they have to hesitate, my lord.
Exactly.
And now, my lord, they have filed an application for condoning the delay by giving a justification. And it is the priority or prerogative of the CEM, my lord, whether to condone or not to condone. He has condoned, my lord, with a justification, and that order is reflected in page 65, my lord. My lord, may kindly produce. It is genuine order, my lord. There is nothing wrong in this order.
No, the point is, we are not talking about the merits of the.
No, I am not talking about a merit.
Now, we are talking about the procedure.
Yes.
Against an order passed by EM,
yes,
it goes to CEM.
Yes, my lord.
CM has passed an order, rightly, wrongly.
Yes. Only no, he has not decided the case.
No,
he has just condoned the delay.
That even then, he may have condoned the delay.
Yes, my lord.
But that has brought certain proceeding, to its finality.
Yes, my lord.
It has given conferred right upon certain parties.
Only the appeal was admitted.
Appeal was admitted.
Yes, my lord. Appeal was admitted.
But he is aggrieved by that
order. That order.
Now you tell me,
my lord.
According to procedure, according to rules or regulation,
my lord,
where would an appeal or revision lie,
my lord,
against an order passed by CEM?
No, against the order is before this honorable court under Article 226. There are
exactly.
Yes, my lord. Okay. Now the case is this: what my friend is trying to project into the merit, whether he was the rightful claim was made by the private respondent or not. But that is CM has not decided into the merit of the case, my lord. CM has not said that the private respondent is the norm.
If I understand correctly, the only issue to be decided by this court,
yes, my lord,
is on the issue of condonation itself.
Exactly, my lord. Exactly, my lord.
Whether that the application for condonation was allowed on merit,
yes,
considering all taking all aspect into consideration, whether it's within law, whatever.
Yes, my lord.
So I think to that extent,
yes, my lord,
this court has got that jurisdiction.
Yes, that's why lordship.
That's all.
Yes, my lordship. Now my learned friend has already pointed out, but one thing, my learned friend he stated that appeal has not been filed, my lord. That is there on the record. Lordship. Now my what I'm trying to say is, since it is the admitted fact on record, they have filed the condition application on the wrong provision. Therefore, let this court let them, if required, then let them file a fresh application in a proper provision of law.
My lord, if the law is wrong, the court cannot take cognizance of that application. The correct provision is not required, my lord. Even provision is not required even to be mentioned, my lord. Provision is not even required, my lord.
You see, understandably, Mr. Sama, understandably, if there is an unreasonable delay in preferring the application, you say 3,000 days or so.
Yes, my lord.
And the court has taken a call on that. So what this court has to do is to examine the impugned order and see on what ground the CM has passed the order, whether they are sufficient ground to condone the delay,
yes,
whether it's plausible or not, All those things has to be considered. Provision of law is immaterial because the Limitation Act is not applicable.
Limitation
Not
Act is
applicable. But like I said again, on unreasonable delay, the court can take that.
Yes,
that issue into consideration.
Yes, Lordship. One thing is very clear, Your Lordship. In the district council, in this
statute
Garu
provides
Hills,
that an appeal has to be filed
Autonomous
within 60
District
days.
Council, Social, Custom and Usages Balloting Act, Section 8, Bracket 2, has specifically provided for filing an application if there is any delay. Is it written? Any person, I read the Section 8, Bracket 2. Any person aggrieved at the order of the revenue member under subsection 1 above may prepare an appeal to the district to the chief executive member within 60 days from the date of the order. So this provision, this section should happen applicable, and they should happen filed under this provision, my lord. But they have not done so.
My lord, may I kindly come to page 48, my lord, of the petition. 48 of the petition, my lord. Of the writ petition, my lord.
Yes.
My lord, may I kindly see prayer for condonation of delay in appeal under Rule 8.2 of Garo Hills Autonomous District Council Validity Act 1958. Yes, so my lord. Now adding to this, my lord, and in the matter of an application under Section 5 of the Limitation Act for extension of limitation period. What's wrong then, my lord?
You are only on the ground that
correct provision was not filed.
This application was filed on the wrong provision.
Wrong provision, and also, Lordship, they have not properly explained. And secondly,
now, my lord.
And secondly, the impugn order stated that it was past ex parte. That ex parte was never that was not never ex parte. We have issue notice in the impugn order. They have mentioned clearly that order was passed. The EM, their allegation, not allegation, in the order, the chief executive member has clearly mentioned that the EM has passed ex parte. Never. That's why I'm from the beginning, when I trying to make a submission, I'm saying that notice has been issued to all the concerns. They were there, but
if that is the case, my friend can go.
Just a moment,
Mr.
Yes. So that's why I'm trying to say that instead of dealing with the delay, they have touched the merit. They say that the one of the ground for condoning the delay also was that the order was passed ex parte.
Exactly.
That is there is no ex parte. That's why I'm said prior to passing of the order.
So that will
EM.
That will be your stand.
Yes.
That will be your stand. One of the grounds.
Yes.
And they will refute it. So it is for this court to decide whether what is proper and what is not.
No.
So
and
next
another
point,
my lord, I have one more document. Is this one? In this application I have just received it. The person who filed Valencing CH Marap, he has also written one letter to the petitioner here in saying that he don't want to pursue the matter. That means even if the condemnation, if this matter is allowed, even the condemnation is allowed or under challenge, he said that he will not pursue the case. That means he is not going to file an appeal.
No, that is not for you to say. Who is appearing for him?
I am appearing for the respondent.
So did he say
something he bring from his pocket?
Not from
that
the
is not a part of the record.
We will.
My lord.
We will bring it.
You will get his instructions.
My lord.
Let him bring the instruction regarding. I have
that is immaterial. That is immaterial.
This is immaterial, my lord, because when
this letter they have submitted to the EM, lordship.
That you see, Mr.
By raising the voice, you cannot prove your case. Now you listen.
You need not worry then whether this order is passed against you or for you. You need not worry, because if you feel that late, see, when it goes back to the proper authority, the matter will not be pursued. Then matter ends there.
Yes,
but we are not on that.
Yes.
You see.
My lord, what I want to point out is this: my learned friend has two objections. One is that it was not filed under the proper provision of law. Now I have shown, my lord, that proper application was filed under the proper application of law, my lord. That is the wrong submission what my friend was trying to project. Second point is this, my lord, that it was an ex parte order. The claim of the private respondent was that it was an ex parte order and we was not aware. And notice they have received, my lord. That notice is not before this honorable court.
There is nothing on record, Lordship.
There's nothing on record to show that a notice was received by them. And even if notice was received, my lord, they could have filed a review application against this order. By filing a review application, they could have produced the notice, my lord, and then the CEM has the opportunity. They could have done it. They could have filed a review.
That would have, yes, that would have been a proper.
Because file is before the CEM, my lord. He could have checked it whether they have received or not. Moreover, my lord, now something he has pointed out from his pocket, my lord, and he tried to place
That's
it.
a different thing.
No, I'm just pointing out. I'm just pointing out, my lord. Normally, what is the practice, my lord? Is the mama who is to file an application to register his niece and her husband, my lord, for registering the Nokma, my lord. Now, the mama filed the application on behalf of the Mahari. He personally cannot decide, my lord. My lord may kindly see that the application, there is a seal also. It is the entire Mahari take a resolution, and then he is just like a peon, my lord, just go and drop the paper, my lord. Now, suddenly he give an application to him that no, I don't want to pursue this matter. Can this court take in cognizance of this kind of letter when it is not on oath, my lord?
I'm bringing on record because that letter also is submitted to the EM. I'll bring it on this one. They have submitted to the EM also. On the another stand, the person who filed the continuation application, he is nobody, because to substantiate my allegation, I have annexure, kindly annexure 6. There is a High Court order from this bench.
Exactly, Mr. Sawa. You could have gone on review.
Yes, exactly, my lord.
You see, if there are you see, error apparent on the face of
Face
the
of the record is there.
then that is a and the CEM is well within its right to consider your application.
Yes,
but
and the decision may return in your favor.
Yes, exactly, my lord.
One thing is that because the CEM as earlier
now, you see, even if you have come by way of writ application, the power of this court as regard judicial review in such matter is very limited, because you have to understand that, well, by and large, the court will not substitute its own discretionary power than that which was exercised by the original court. Condonation of delay is an exercise of discretion based on, of course, certain facts or logic, whatever. But in the end, this court will only have to look at the procedural defect.
Yeah, exactly, my lord.
Yes, one more thing is because, Lordship, one thing is, let me just make another, since the review, Your Lordship, because they have not decided on, as submitted, they have not decided on the merit of the case. But while deciding the conditions of delay, they have touched the merit of the case also. And then now what I'm trying to say, let me just complete my submission, then allow, otherwise how can I will try to convince the court what I'm trying to say, then they can make an objection. They should allow me to make my submission complete.
Where's the impugn order?
This impugn order, my lord.
Page 65, my lord.
Page 65. Before that, my lord, I will like to emphasize on the Annexure 6, my lord. It will have some bearing in my case, which is very important, my lord. This Annexure 6 is very important, page 30. That impugn order, of course, that is starting from page 65 to 67. It's a very quite long 3-page order.
What is page 35? Yes, what is page 35?
This is the impugn order. May I read it?
Page 35?
Oh, page 38. 30, yes, 37. That type copy is there, my lord. I will just come to. Is that from page 43? This is just a type copy because that is not clear. Same thing, but only just this one. The judgment may I read, Your Lordship. It's page 44. It start from page 44. page 44. Now, why I'm stressing this one is I think it will have some bearing in my case, because he claimed that he is the Nokma. But in this judgment was never been challenged and is still operation. Now, why I'm saying that? Because in this order, may I just read it, Your Lordship. I will read it from para 1. It will take only for some time. I have heard Mr. B.K. Jinder, learned advocate, assisted by the M.S. Jinder advocate, appearing for the petitioner. Also heard Mr. Kinjing, senior advocate, assisted by Mr. S.M. Suna, learned counsel for petition for the district council, and S.P. Mahant.
Go to the main.
Yes, main lordship. I'll just take it to the para 5 and 6, my lord. Para 5 and 6, then para 5, 6, 7. This only. Mr. Mahanta, learned counsel for learned counsel appearing for the respondent number 3 and 4 has vehemently opposed the contention of the senior counsel for the petitioners. The respondent number 3 and 4 have also filed a detailed counter affidavit starting from para 4 of the counter affidavit countering or aberment made by the petitioner in the writ petition. The learned counsel for the respondent and had further submitted that the impugned order dated so and so has been passed after pursuit of all the document dating from the date so and so, wherein the respondent lineage has all along been shown as Nokma number 1 and petitioner lineage has been shown as Nokma number 2. The learned counsel for the respondent has also drawn attention of this court to electoral roll number so and so, wherein the name of the respondent had been recorded and shown as serial number 1 against the house number 1 as the Nokma. And wherein the same electoral number roll, the name of the petitioner had been shown at the serial number 167 against the house number 40, and in the column father's name it is recorded as unknown. This all go to show the right place of the respondent as Nokma number 1. Further, to counter the contention of the learned senior counsel for the petitioner, the learned counsel for the respondent has drawn the attention of this court to the record which has been produced by Mr. K.S. Kinjing, senior advocate, appearing for the district council. Mr. Mahanta submit that the impugned order purported on 6/01/2004 has no date in the column serial number, the date of the order sheet. The said purported order sheet has been carefully inserted as order sheet before the insertion and after the insertion of the purported order dated so and so, the date of vice enter, and only the purported order dated so and so has been inserted for the same purpose, which is clear from the page of record. The inserted purported order dated so and so has also no date mentioned in the said order sheet. The learned counsel further stated that the purported application for review as appearing in the Annexure 6 to the writ petition is also manufactured document in the same manner as the document of the purported order dated so and so. The Annexure number 3 and 4 stated that Annexure number 6 on the face of the record reveal the manufacturing of the same as the review of the order dated 17/11/2003 was applied on 19/04/2004, fixed for notifying on 12/05/2004, copy ready on 12/5/05, and the date of making over 12/05/2004. This of the face of the record show the credibility of the said document of the annexure 6 and 7 being manufactured and the place in the record for the ulterior purpose. In fact, the order dated so and so is the real and actual order of review and not the second order of the review is submitted by the petitioner. In this view of the matter, the learned counsel for the respondent state that there is no illegality in passing the order dated so and so, and therefore the same is not liable to be quashed and set aside. Mr. Kinjing, the learned senior advocate, also supported the submission made by the learned counsel for the respondent number 3 and 4 and state that the order dated so and so is the only order of the review and not the purported order dated 15/01/2004. In this view of the matter, it's also submitted that the order dated 20/05/2024 has not been passed for any legal purposes or for any other ulterior motive, but the said order 2005-2004 have been passed after considering the entire matter in its proper perspective, and there is no illegality of the said order dated 2005-2024, and the same is not liable to be quashed or set aside. I have heard the counsel appearing for the respective party at length and also pursued the relevant document and also the record that has been produced by Mr. Kinjing, senior advocate, upon consideration of the entire matter in its totality and upon pursuit of the said document and record. I am the consideration opinion about the genuineness of the annexure 6-7. To me, the said annexure 6-7 annexed with the writ petition appear to have been inserted in order to defeat the order dated 2004. The said two annexures have also been inserted to show that the order dated 2005-2004 has been passed. The second review order, after giving my anxious consideration in the whole matter, and basing on what has been stated above, I have come to the conclusion that there is no merit in this petition, and same is accordingly rejected. The second Nokma Sri Balen Marak rejected the second Nokma Sri Balen Marak as the geological law. The respondent number one. Respondent is the Nokma number 1 and the genuine original Nokma of Mandagri Akunglan as the record of the ancestor. Now, why I am trying to stress this order is this petitioner here who filed an application before the court of CEM challenging filing an application for continuation delay. He has filed another. There is a case claiming himself to be a Nokma, but in this order, his claim as Nokma of Mandagri has been rejected, and he has tried to. In the record is clearly mentioned that he has bring those manufactured document, all those try to defeat, try to get the order in favor by submitting all those manipulated. That is in the record, Your Lordship. Now in this order, why I'm submitting this before this on record is this person who filed an application of continuation of delay. He is nobody. Till now, this order has not been challenged. This is the order, and this order is still in force, and this is still operational. He is nobody. He is not. He is claiming that he is a Nokma. He is no more Nokma. The real Nokma is that. This one, my lord. He is a real Nokma is Lepson Ramjing. This is Sangmadat in the notice, my lord. Not balancing, my lord. That's why I am saying that first. He is nobody to file an application. He has no locality to file an application for continuation of delay. Secondly, there is no ex parte. And thirdly, I have stated, even they have mentioned there is a wrong provision of law there under that section. And fourthly, no proper explanation has been given for the ground for continuing the delay, my lord. That's my submission.
Before my learned friend proceeds any further, your lordship would have to first demonstrate that he has come before this honorable court on the ground of condemnation of delay. The pleadings before my lords are absolutely silent on that issue. I recollect this because this matter at some length was heard before court 4. Your lordship may kindly examine the petition before my lords.
He has come on the premise of the propriety of the passing of the impugn order.
None. Not on the issue of delay. Well, before my learned friend actually argues on the issue of delay, well, the pleadings would have to bear him out. For the sake of the argument which is in place by my learned friend, my lord, if I can just reply to it, my lord. My friend is not coming to the impugn order my lord may kindly produce the impugn order, page 65, my lord. And I have also shown, my lord, that an application for a delay of condoning the 3,000 something days was filed, my lord, under appropriate provision of law. The first submission of my learned friend was this, my lord, that it was an incorrect provision of law and how they could have condoned the delay. He said, my lord, let them go and file an application, a fresh application, as per the proper provision of law, my lord. That was his submission, first glimpse of his argument. So, my lord, I have shown, as per the record, his record, my lord, that the application was filed as per the correct provision of law. And to that, my lord, it is not his case also that he was not heard in the delay of application, my lord. He was heard. He has filed his show cause in that application which has been filed by the private respondent. Now, my lord, may kindly come to the order, my lord, page 65. It's a very interesting order, my lord. It's a very lengthy order. I will just read out. My lord, may kindly bear with me with the thing because some of the word is not printed properly. I will just read out. This case is filed under section 5 of the Limitation Act 1963 for the condonation of delay in filing so and so against the ex parte order dated so and so. In GD number so and so, both the parties has filed their respective affidavit and show cause, etc. Both parties are present and along with their counsel, the court also heard the submission of the counsel for the parties. So this is not a case, my lord, where he was not heard, my lord. The counsel for the petitioner submit that that first of all, registration of so and so is illegal and unsustainable when so and so case number, my lord, filed by the predecessor in interest of the present respondent for registration of so and so separately as separately. This Darubogri as separate aking has not been disposed of, abandoned. He also brought to this court knowledge that on so and so date, that is 24th February 2010, the EM in charge Land and Revenue has passed 3 orders in the instant case. In the first instant, order was passed for summoning the present petitioner, that means the private respondent, my lord, and others. Next, he passed the order 2 orders which appoint the respondent and NOCMA and approve the GT. So, my lord, what happened? On 24th February 2010, my lord, 3 order was passed. First order, my lord, summoning the parties. So, he should have waited where both the parties appear, or may not be that the other party may not have appeared and an ex parte order could have been passed. But on the very day, my lord, he has registered a NOCMA. On the very day. And he has also approved the GT on the very day. Whether that is permissible or not, that has been decided by the first appellate court, my lord. Not into the merit, my lord. They said, okay, fine. We are going to condone a delay because the record speaks, my lord. On the very day, 3 different order was passed, whereby appointing him as the NOCMA, whereas by the GT has been approved, and he also shows that a notice has gone to the private respondent. That is impermissible, my lord. So now, my lord, an appeal has been filed by the private respondent before the CEM, and delay has been condoned because according to the CEM, my lord, that is his satisfaction, my lord. Now, whether his satisfaction was proper or not, my lord, this court has ample power to see, my lord, whether it was a correct appreciation of the facts which has been placed by the private respondent or not. But he has been satisfied, my lord, that yes, it was an ex parte order because 3 different order in a single day could not have been passed, my lord. That is why he has condoned the delay, my lord. And this order, my lord, my friend is not reading. That is the actual order, my lord. And now it is not the case, my lord, that he will be dislodged from the NOCMA-ship, my lord. He will be heard, my lord. Evidence will be laid down. In EM order, my lord, evidence has not been recorded. As per the Doresama case, my lord is very much aware. 4 principle has to be followed, my lord. Evidence has to be laid down. Can my friend show, my lord, from his pleading or from the record, whether evidence was recorded, my lord, when he was registered as a NOCMA? Cannot be shown, my lord. Now, again, my lord, the second point, what I would like to answer, my lord, that he has raised, that he says, my lord, the person who was before the appellate court, my lord, he has no locus because he has lost 1 round of litigation before the High Court. Very well, my lord. This order, he can place it before the appellate court, that he has no right, how he can come again for the 2nd round of litigation. He will get enough opportunity, my lord, to prove his case. He is just stalling, my lord, the matter. The matter is getting stalled, my lord, in the appellate court. Now, my lord, the matter was filed in the year 2022. My lord, we are in 2025. The matter is pending, my lord. He could have gone and shown these papers that, see, his claim was already rejected by the High Court. Now, you cannot override the High Court's order. He's not showing that. He has not even brought into the notice of the appellate court, my lord, that the High Court's order exists. It is his duty, my lord. He is the party to it. And he was very much aware. No order asked his claim, my lord, that the claim of the private respondent is barred now, my lord. That has not been brought into the notice of the appellate court. This is my submission, my lord. So this petition cannot be entertained.
My learned friend is citing the Doris Sama case. Even para 8 of the Doris Sama case also stated when there is a proper record, is the evidence that the document is sufficient, then is recording of the evidence is not necessary. that was there. And now what I'm trying to submit.
Let us read, my lord, para 8. My lord, I have never seen this. This is para 8 where he said evidence is not required to be laid down, my lord. If I may only just come on. I think it's putting the cart before the horse. The limited issue is, my lord, that the appellate court has entertained the condonation of delay application, condoned the delay, and put the appeal for hearing. Appeal will be decided on merits. Now, the propriety of the order by which delay has been condoned is being challenged by my learned friend. I'll just take 2 minutes of your lordship's one line I will read, my lords, and whether then he can challenge, your lordship will kindly see. Page 67. Put along. My lords, may kindly have a look at page 67, my lords. These are the findings of the court. My lords, first, second, third paragraph.
Yes.
This court, after hearing submissions from both the parties and from the materials on record, have considered that the application for condonation of delay is necessitated since the present petitioners have not been summoned by the EM in charge Land and Revenue before the creation of the new Aking called Dari Bogre Aking out of the Aking of Mandalgre Aking. Petitioners were not present while passing the impugned orders. Counsel for the opposite parties, that's my learned friend's clients, did not dispute with the delay explanation. My lords, may kindly take note of this. He does not dispute, my lords, that we have been served with not been served with notice with delay explanation. Instead, objected the application under the Limitation Act 1963 and stated Limitation Act is not applicable in Garo Hills, so he prays for rejection of the petition. That's his limited rejection. Then, my lords, the court says if the argument for the counsel for the opposite party is true, then application for condonation of delay is unnecessarily and appeal can be filed at any time beyond limitation period also. At the moment, I am not concerned with this argument. I am also considered that the explanation provided by the counsel for the petitioners and the record clearly speak that the impugned orders have been passed ex parte in the absence of the petitioners only while creating a new Aking called Darik Bok Grey Aking. Therefore, delay in filing can be attributed to the lack of knowledge of the petitioners of the impugned order, and no negligence or inaction or lack of bona fide can be imputed to the appellant's petitioners, and no malified intention to harass the opposite parties by this appeal. I am also aware of the provisions of the Garo Hills So-and-so Act 1953, Article 48, which empowers the courts in Garo Hills Autonomous Area to be guided by the spirit of CPC but not bound by its letters. Based on the submissions of the parties and under the above observations, application for condonation is admitted, delay is admitted, and the prayer to file a delayed appeal is hereby allowed. Accordingly, main petition stands disposed. So the main appeal as well as yet to be heard. It
Exactly.
is not disputed that it is an ex parte order.
See, Mr. Sawa, if we are repeating the same thing again and again, if you have a case, having pointed out all those, see, the order of the High Court, and then the challenging the bona fide of the petitioner or the respondent, that can be brought before the appropriate court.
First, the appellate court will hear it.
And the matter will be decided.
Yes.
So by delaying this matter, I'm not saying delaying, but by having this matter in this court for so many years, you are doing yourself a disservice.
This lordship,
you are not able to proceed with your own case.
That is the case, my lord. Let the petitioner may be allowed to file a review before the court if necessary. That observation may be made.
That is up to you.
No, because otherwise, my lord, Otherwise, my lord, if that order, that observation is not, they will reject that this has been dismissed, this, that, and again they will plead that.
So your lordships may clarify that your lordships have not heard us on the merits of the.
Yes.
Moreover, to that extent, my lords, we are willing to do that. Otherwise, also, my lords, condonation of delay or not is, my lords, the discretion of the court concerned.
That's what I earlier. That's what I said.
Yes, and moreover, my lord, one more point. What my friend is saying is this: the person is not claiming that he want to be the Nokma of that hacking. Hacking was bifurcated, my lord, and his grievances is this: I was not heard before the bifurcation. That is not been pointed out by my friends.
Exactly. So you will state your case before the
yes, my lord.
Before the
dispose of in merits, my lord.
Yeah, the appeal can be disposed of merit, or you can file a review if you want to. That's up to you.
Yes, lordship. That observation that maybe made that maybe allowed to file a revision review before the.
No, that's your prerogative.
Yes. It may not fall from my lord.
It is not necessary. You see, it is not necessary for this court to pass any order in that respect.
Yes, exactly, my lord.
The point being that when this matter is sub judice before this court, so that period, that period will not be counted as far as limitation is concerned.
Yes.
So you can safely file your review, going back to the the initial period of when the appeal was filed. That is your. I mean, you can state that case before
Even in my lord, that in the order that liberty giving for filing review, that may be just only just as a liberty. Other they will raise their objection.
That was not even prayed by him, my lord. Now when we are pointing out his
I'm not saying, but yes, of course, that is not my prayer. Otherwise, I will get instruction, clear instruction. Let his matter may come after some time, my lord.
My lord. If I may just point out, as I pointed out, it is the issue of delay which has been condoned by the court, my lord, for hearing of the appeal. I don't understand what review my learned friend wants to file. And if, my lords, my appeal does not merit any consideration, it will be dismissed in due course. Yes. So on the issue of limitation, my lords, I don't know why we are getting stuck. It is the discretion of the court. Court has said, my lords, and your lordships will kindly see that they don't dispute it. Once they have not disputed it, my lord, then any challenge is maintainable. That's a question I ask myself.
No, we have disputed, but in the order, in my pleading, we have mentioned, but only order they have recorded. I give some time, maybe given. I will on the next date. I will just get a clear instruction either to pursue or this one, lordship.
For the interest of justice. Then, my lord, he was heard. We was heard, my lord. Then an order should
because
come from this honorable
it is
court,
on the face of record. Notice has been served, and that person who filed an application, he is not even a Nokma.
We will not go back into that. You see, we are not again. See, I'm reiterating that the merits need not be discussed.
Yes, my lord.
Because that is not the issue. That is not the issue before this court. That is a different thing altogether.
Give me one more time. I will try to satisfy.
He cannot change the record, my lord. My lord, the matter was heard, my lord, in length.
He wants to seek instruction to withdraw.
Yes, let me get the instruction.
Let my friend be satisfied, my lord.
Yes, I will know the next date. On the next date. The next date.
But Mr. P.T. Sangwal, counsel for the petitioner. Also heard Mr. S.D., counsel for the respondent GHCDC, and Mr. A. Paul, senior counsel for your respondent number.
Private respondents number 428.
After the matter was substantially heard, Mr. P.T. Sangwal has sought for accommodation on the ground that he would seek specific instruction from the petitioners as to whether to proceed with this matter or not.
Yes, lordship.
Proceed with this matter or not before this court. We'll fix this matter on 4th.
Friday, my friend can take telephone instructions. Yes, my lord, and otherwise again it will
Friday,
be again.
Because Friday, my lord, I will not be available, lordship.
That may be recorded, my lord. He will definitely lie, my lord.
Let it be 4th. After 4th, my lord.
Let it be on 4th, my lord. On 4th.
After 4th. This is not urgent also. No, It's even why there so much? There have been sufficient time may be given because.
Okay, fifth. This is not on fifth.
Much less lordship.
For the hearing.
Much less lordship.
Item number 9.
Yes, who's appearing here?
So I think Mr. Sen is there for the Millard's petitioner. Before which court? Millard's, I'm instructed, Millard's, I think there is a defect in the Millard's cause list. This same matter is again shown listed before my lords on Friday.
Friday?
Millard's. Item number, I'll just point out, Millard's. I have the list. Just give me the list, please.
Item number 6.
Item number 6, Millard's, is listed as item number 6 before my lords. This, I think, Millard's, this has happened in a few matters. There's duplication of matters that is happening. Lordships can take it up on Friday. In all fairness, Mr. Sen might have seen it,
Yes,
that matter is coming up on
but
Friday.
then, no, in any case, he should have gone through the cause list and would have noticed that it's fixed today. He may have mentioned that the matter is also fixed on Friday. But not appearing means disrespect to the court.
I would only, my lords, in his defense probably say that probably he missed it. I'm sure, my lords.
Concession will be given.
Season counsel, my lords, I don't think there would be any deliberate
as far as other
disrespect. There will not be any deliberate disrespect from my side. I'm sure, my lords.
No negative imputation. On premade parties, let's this matter on Friday.
I'll oblige.
Item number 11.
Please, Your Lordship. Your Lordship, this matter is on a similar situation as the previous item, where this matter has been listed on Friday as well. As Mr. Nongri is on his legs, Your Lordship, can you have this matter on Friday?
Your Lordship, I'm being led by Mr. Shulai in this matter, and on Friday we'll have he has some difficulty, Your Lordship. It can be listed on Friday, Your Lordship, but we'll be praying for an adjournment.
Yeah, because since there's a duplication of a listing, and so that it will not be confusing.
Yes, Your Lordship.
Because again on Friday it will be called up.
Yes.
If this matter is posted on suppose Monday, then again it will be called up.
Your Lordship. Let it come up on Friday, Your Lordship.
This is matter on Friday.
Right, Your Lordship.
Item number 12.
Here, I think the appellant has.
We have completed our submissions, my lord. Now it's
It's for the state, my lord. I'm ready to do the hearing, my lord. But my written argument is not ready, my lord. Whether it will be taken simultaneously or hearing will be taken today.
Are there 1, 2 matters, 3 matters here?
2 matters.
Two matters are there, my lord. I have completed in border matters, my lord.
But you have not started.
I haven't started.
They are yet to start.
We'll have it next week then.
My lord.
Next.
Or you suggested it?
My lord, next week I'll join online, my lord. It's okay. Let it be Monday onwards, my lord. Any date of convenience. I'll join online, but my lord.
On premade parties, this is matter to 1 week.
My lord. All right.
Item number 14.
May I please, Your Lordship? My lord. This is regular bail application, my lord. I am behind the bar since 114 days.
Okay. My lord, before my friend starts, my lord. As per the last order, my lord, the state was instructed to, my lord.
Yes, whether he's entitled to default bail or not.
Due to certain difficulty, my lord, report is not with me now, my lord. If this matter can.
You could have got a telephonic instruction.
Actually, my lord, off the record, my lord, the IO had come, my lord, yesterday. Because I was on lake, probably left. It was not even left in the office. My apology, my lord. I feel sorry for my friend here.
From my lord, mandatory period is.
You are coming from?
Gauhati, my lord. My lord.
You can always appear online. Not necessarily
Day after tomorrow.
Day after tomorrow, my colleague will appear, my lord.
Okay.
My lord, what happened, my lord? Mandatory period is 60 days, my lord. I am behind the bars is 114 days, my lord.
Exactly.
Yes,
See,
exactly.
that's what I've said earlier. See, now
My-
you have not even come before this court for default bail.
My lord, I have not.
But
That's-
nevertheless,
but-
as far
Pointed
as
out by my lord.
as far as default
Exactly.
bill is concerned,
Exactly.
you see that Rakesh Paul judgment would say that it is incumbent upon the magistrate himself to point out
My lord.
to the parties that this matter is,
My lord.
you're entitled for default bill or something. So we'll listen on Friday.
Friday, my lord.
20.
Mr. Argurum, okay. You suggest a date?
My lord, okay. 28. On 28. 28/11.
28?
28.
That's Friday.
Sorry, I was looking at
28,
that.
my lord. On 28.
Mr. Argurum Ji has
Then suggested it.
submitted that he
What was
has not been able to get specific instruction.
My lord, kindly on December, my learned colleague has some problem. He will appear in
Suggest a date.
Suggest one date. Suggest
any date from December.
We'll have it on 2nd then, Tuesday. Numtuko.
Please don't mind.
Oh, no.
From the IO, as far as the status of the charge sheet is concerned, it is prayed that some accommodation may be granted in this regard, and the relevant report will be furnished on the next date fix. The counsel for the petitioner has no objection to the preamble. Accordingly, as prayed for by the parties, place this matter for further hearing on 2nd December.
Highly.
Deeply. I'm extremely sorry for today. Please don't.